And I see people are joining, which is great. Well, yeah, a lot of people joining now. But I don't see the control. So maybe, Ian, we need to keep them with you.
Sure, I'll do it.
Okay. All right, then I'm ready when you guys are.
Perfect.
Awesome. So okay. So thank you everybody for being here. My name is Joe Kagan. I'm with Woodsmith, Henning and Berman. I'm a member of the board of directors on San Diego Defense Lawyers. Today we have the great pleasure of having Justice John Owens with us from the Ninth Circuit Court of Appeals. Thank you so much for being here, Your Honor. We all super appreciate it. Just a quick brief background about Judge Owens before we begin his presentation. Judge Owens became a federal judge in 2014, and prior to that, he was a partner at Munger, Tollers and Olson LLP, where he focused on white-collar investigations and appellate matters. He served as a federal prosecutor for more than 11 years in DC, LA, and San Diego. And a fun fact I thought from the bio was the television show American Greed actually featured 2 of Judge Owens' prosecutions, which is really cool. So without further ado, I'll turn over to Judge Owens, and everybody want to let you know you can do questions in the chat function, and we'll do our best to address them as they come up, but inevitably some will probably be addressed at the very end. So feel free to bring on the questions. And with that, I will turn it over to Judge Owens.
Hey, well, thank you so much, Joe, for the introduction. And yeah, you mentioned the American Greed. Reminded me that was the first time, and really the only time I've ever done any television. I got a little bit I have, but they brought out pancake makeup for my head. So that was a little, that was a good lesson there. If you have my hair or lack of it, they don't want the glare. So they literally pancaked my head. Well, great, everyone. It's good to be here. I wish we were in person. I think we're getting close to that. But I want to talk to you guys today about an ethical case, actually, involving a law clerk at the Supreme Court who was indicted for insider trading. And so the name of my talk is The Clerk, the Thief, His Life as a Baker, Ashton, Embry, and the Supreme Court leak scandal of 1919. So if we could go to the next slide, Ian Friedman's working backstage. All right, so December 16th, 1919. Just freeze it right there. Ashton Fox Embry is a law clerk for Justice McKenna at the Supreme Court of the United States. And he submits his resignation. Now, you're all practicing law, you have staff, associates, people move on, it happens. I don't think any of you have received a resignation note quite like this. He writes, "My dear Mr. Justice McKenna, by reason of my bakery business, having expanded to such an extent as to require practically all of my time, I feel that in justice to your work and my health, I ought not to try to continue as your secretary," that's what they called law clerks back then, "for it seems impossible for me to do my full duty to both places." So next slide. "I therefore beg to tender to you my resignation as your law clerk effective today." So he did not give 2 weeks notice. He's quitting that day. "In resigning my position, I desire to express to you my deep appreciation of your helpfulness to me in so many ways, which has meant to me more than I can tell. Yours sincerely, Ashton Fox Embry." So let's freeze there for a second. For those of you who have to deal with personnel, maybe you're doing employment defense. Employee comes in and says, "Look, I got to quit. I got to quit today. I got to quit today because of my bakery business. And it's too hard for me to work for you because I have this bakery business." So that's the stated reason. You guys can assess whether or not you think that's the genuine reason as we go through the presentation, but that is the reason he gives. So if we go to the next slide. Justice McKenna accepts the resignation. The within resignation is accepted to take effect this day with regrets for the necessity, signed by Justice Joseph McKenna. There's an interesting thing here. He signs it December 16th, and that sure looks like 1916 to me. Doesn't look like 1919. Now, we all made that mistake when it's January of a certain year, you write the last year on there. But to get it 3 years off in December is a little odd, and there may actually be some significance to that, which we'll talk about. Okay, so we go to the next slide. Something else happened on December 16th, 1919. A bunch of stories came out in big newspapers like the New York Times. Let's go to the next one. Another lead story, leak rumor probed. Supreme Court's dry decision said to have been known. I think that means ahead of time. Go to the next one. DC gamblers gave tips to Wall Street. Well, that's obviously not a good headline. And one more. Leak on wet decision being probed here, and we'll talk about that. Department of Justice going to the bottom on story of advanced information. Mention DC lawyer. All right, so those of you who do employment law, you can assess, okay, well, the stated reason was the bakery. Maybe this had something to do with it. So let's go to the next one. So who is this guy? This Ashton Embry, the superstar baker who quits his clerkship at the Supreme Court because he says he's got to spend time in his bakery business. Well, he's born in 1883. Go and tick through here, Ian. He attended what was called, we can freeze there actually. He attended what was called the District of Columbia Law School, which is now became part of George Washington. So if there are any George Washington grads on the line here, this is not going to be one of your best alumni stories. He started his career at the Department of Justice in 1905, and in 1908, he was a law clerk to Judge Sanford, who later became Justice Sanford on the Supreme Court. And back in those days, Judge Sanford, very similar to the job I have now, would actually ride the circuit. He actually would travel around the circuit and visit various courthouses, and that's how it worked back then. They did not have Zoom to do their court duty. So if we could do one more click here. So this is one of these practice pointers, right? So if we have young attorneys on the call today, just remember, this is probably not what you want to be putting in writing. So this is Ashton Embry writing. The judge, he's talking about Judge Sanford, and I have just returned from Greenville, where he held court for 4 days last week. Most of the cases were criminal, illicit distilling and so forth, and the defendants presented on the whole a pitiable spectacle. Ignorant, low-browed cusses who undoubtedly would be better off in jail than at large. Now, he wrote this on the judge's stationery. So again, if you're going to have these conversations about pending cases, be careful what you write. Be careful putting them on the judge's letterhead. You never know where they're going to end up 100 years later. A federal judge is talking about it. So again, just a practice pointer, emails. Emails are like diamonds. If they clear the server, they last forever. Be very careful what you put down in emails. You never know, they can come back to haunt you. But anyway, this guy was kind of a superstar graduate. He's clerking these big places. If we could click again, Ian. He joined the Solicitor General's office in 1909 as a stenographer. Again, a low-level position, but he's still in the Solicitor General's office, so that's a big deal. And then one more click. Then in 1911, he begins working for Justice McKenna. So let me talk a little bit about the duties of law clerks back then. So I was a law clerk once upon a time to Justice Ginsburg at the Supreme Court. And my job for the Justice Ginsburg was 1 year, and it was purely assistance with her cases. I helped her with speeches and little things like that, but it really was the job of the justice. Back then, the law clerks had dual roles. They did do work on cases, but they also handled a lot of the administrative work for the judges in terms of paying bills. They really were, that's why they were called secretaries, really was more of a secretarial function than law clerk function. As time went on, it became more of what you think of as a law clerk, less as a secretary. But here's the important point. They did have access to inside information in that position. So if we click again, Ian. So here's the proof of that. Dean Acheson, who was the Secretary of State for President Truman, was an advisor to the Kennedy administration, longtime Washington insider. He wrote a book about his life. I think it's called Morning and Noon. And in that book, he talks about his time when he was a law clerk at the Supreme Court. And he was a law clerk at the Supreme Court the same year as Ashton Embry, that 1919 term. He was there. And in his autobiography, Dean Acheson writes, each justice in those days had a docket book. One of the joys of being a law clerk was to open the book on Saturday afternoon and learn weeks ahead of the country what our masters had done. So let's take a moment here. For those of you who are practicing lawyers, many of you in San Diego probably do work for technology companies. You know stuff ahead of time. You know sometimes information that could be very valuable. Maybe the company has really good news coming out, or maybe the company has really bad news coming out. Either way, you're in a position to make a lot of money on that illegally, of course. We know the Supreme Court has said that lawyers who have this access to information, O'Hagan, I think is the case, that if you have access to the information, if you trade on it, that's insider trading. Acheson establishes that law clerks had that ability. And we all know as lawyers that this is a problem, that lawyers do get advance notice and they get into trouble. Those of you might recall about 8-9 years ago, a very prominent lawyer at Qualcomm actually went to jail over insider trading, making trades with his brother through an offshore account. So these things are real. These things do happen. People that are in our legal community, just a reminder, you don't want to do this, but we'll see what happens in this case. All right, so next one. All right, so what's the case? So there are actually two cases where this insider trading happens. The first is this case called United States versus Southern Pacific Railroad. And if you think about it, it's the perfect case to trade on. Because in this case, the Supreme Court ruled that the Southern Railroad's patent, or their right of way in a sense, was invalid. And the price of the stock dropped. So think about it. If you know ahead of time that something that the railroad thought was very valuable, all of a sudden isn't valuable, you could do things like what's called selling the stock short to make a lot of money. So if we go next, and that's exactly what happened. People on Wall Street knew about it ahead of time. They sold that stock short and they made a lot of money. Let's go next. An investigation rolls out and they very, very quickly figure out that Ashton Embry is the source of the information. And they investigate 3 others associated with Embry, a guy named Mayer, a guy named Moses, and a guy named Graves, who actually works in the department. And we're going to talk about all of them in a moment. So let's go to the next slide. How did this story come out? Recall 1919, or November 19th, 1919 is the railroad case. The very next day, talk about a different kind of Washington, D.C., there's this reporter, this guy with the bow tie, whose name is Marlin Pugh. And he actually goes to Chief Justice White's home. He knocks on the door and he says the following, if we can click. There's Justice White on the left. There's McKenna on the right. They're very close friends. And that's also a significant part of the story we'll get to. And Pugh tells White, hey, a source of mine have offered an opportunity to invest in a scheme involving the Supreme Court. This is obviously a big deal. White hears this, if we could click. And according to the reporter, Chief Justice White started crying. And then he went out and he informed the Department of Justice, hey, we've got a major problem at the Supreme Court. Let's go next. So how did this scheme work? So I'll just call next Ian a bunch of times here. So let's go next. So there's this source. The source is the reporter source, Mr. Pugh's source. And so the source, if we go next, gets in touch with this guy named Rachofsky. Rachofsky is a friend of the source. Rachofsky says, hey, Mr. Source, I know people who have excess military equipment. Remember, this is 1919. World War I has just ended. There's all kinds of surplus military equipment, and people are trying to figure out what can we do? Can we make a quick buck? If the U.S. is going to get rid of this stuff cheap, maybe we can sell it overseas. For example, there are revolutions around the world during this time. There's war in Russia. Maybe we can do it then. So let's go next slide. So Rachofsky introduces the source to this guy named Mayer. Mayor's retired military. Mayor's the one who has the access to the military equipment. They start talking to the source. The source claims he has all this money. And Mayor says, well, look, if you have as much money as you say you do, I want to introduce you to my friend. Next. Moses. Moses is an attorney who shares the office with Mayor. Mayor says, talk to Moses. Moses may have something for you. So the source talks with Moses. Moses says, I know someone who has the inside scoop at the Supreme Court. And that is, if we go next, that's my friend Graves. Graves is the DOJ attorney. You're going to see how this is going to circle back to our friend Embry here in a second. And Moses says, Graves is the guy. Graves now talks with the source, and the source says, I'm not going to tell you who it is, but I have a source in the Supreme Court who can give us the information ahead of time. We made money on the railroad case. There's another case coming up where it can make even more money on. That's the case we want you to invest in. And so then the next one, aha, here we go. Not only did Embry work at the Justice Department with Graves, remember we saw that in the chronology, he owned the bakery with Graves. He's the fellow baker. So when you look at it, it was actually very obvious who the source was. It's the guy who owns the bakery with Graves, the very guy who claimed he had to quit because of the bakery. So Embry was found out very, very quickly. Let's go next. So it's one thing if the source is going to tell you this stuff, you got to be able to prove it. And so for those of you who have maybe worked on criminal cases or even in civil cases, if you have the guy on tape saying things, it's obviously a much more powerful case to present in terms of a criminal prosecution or to a jury. So again, this is 1919, and they actually were able to wire up the source to record. However, this is not 2021, this is 1919. The equipment back then was not quite what it is now, and it's called a dictograph. So let's go next. And so a dictograph was this huge machine, almost like those old record players, massive machine. And if the people walked in the room and there's this massive machine sitting next to this guy, they're going to get very suspicious. So what they do is the source, one time he pretends he's sick, and another time he pretends he's hungover. And so they actually have the dictograph underneath him, and he's propped up on pillows. In fact, in one of them, they said they actually sprinkled alcohol on the sheets of the bed so it would smell like he had been really drinking. And so this machine is recording these conversations between these guys. Next. And there are these lengthy conversations with the co-conspirators, Mayor, Moses, and Graves. Now, I want to be clear that the conspirators, they're a little bit cagey, meaning like they didn't say, okay, this is the name of the case, Ashton Embry's our source. They're kind of talking around it a little bit because they don't totally know this guy. This is very common in criminal cases. People rarely come out and just say stuff. But if you read the conversations in context, it's pretty clear what they're talking about. If you have other information to put on top of this, it's clear that this coded language they're using, they're talking about an upcoming case. And so they tell them, if we go next, they say the next case that we're going to trade on is what we call the wet dry case. That's going to be decided in a few weeks. That's where we're going to make the money. And again, this is very similar to the railroad case. It's kind of a binary yes, no. Yes, the alcohol company can do something, or no, it can't. And that is going to directly affect the stock price of the alcohol company, much like the railroad case is going to directly affect the stock price of the railroad. So it's a classic insider trading case. Next. So they decide we are going to arrest these guys on December 15th, but before trading opens in the stock market. So that's the plan. So let's go next. Here's the problem, though. The prosecution has got evidence that these guys are up to no good, and I think we all can recognize why this seems improper. But again, this is a really long time ago. This is before the modern security laws existed. So it's a little unclear what law did these guys violate. Let's go next. So there's no insider trading laws in the book. So they come up with this theory, which actually had existed before. It's a convoluted theory. It's the conspiracy to deprive the United States of its lawful right and duty of promulgating information in the way and at the time required by law or departmental regulation. So for example, what they're saying is that the United States has a right to announce certain information. And by these guys doing what they did, they in a sense co-opted the ability of the United States to do this. And they released the information at a time different that was required by law or departmental regulation. This is based on a case called Hale versus Henkel, which is a really old case, which dealt with wheat futures. And there was a government official who had information about the wheat futures and was going to make money on that. And that's how they prosecuted him, again, because this is before the insider trading laws. And it's very similar for those of you, this movie's a little old now, but there's a movie in the 80s called Trading Places with Eddie Murphy and Dan Aykroyd. And the plot of that movie is about the orange juice futures and manipulating the prices there through insider trading. Actually, that's actually very similar to this Hale versus Henkel case. So again, no clear legal theory, and the lawyers who are representing Mr. Embry, because they were indicted under this theory, they challenge it. So let's go next. They challenge it to the trial court. The trial court denies the challenge. They challenge the theory to the Court of Appeals. The Court of Appeals opposes the indictment, denies the theory. So there's only one more place they can go. So go ahead and click. They go to the Supreme Court. So let's think about this for a second. You have a law clerk, Ashton Embry, who has been accused of defrauding the Supreme Court by announcing the decision effectively, or using the decision before the Supreme Court was ready to use it. And so they got to go to the Supreme Court. They actually hire a really good lawyer. They had a very top level lawyers. It was a high profile case at the time. And Frank Hogan, this is the Frank Hogan, not the Frank Hogan who was the district attorney, but the Frank Hogan of, the law firm Hogan and Lovells, which is a very top DC law firm, used to be called Hogan and Hartson. The Hogan from Hogan and Lovells was Ashton Embry's lawyer. And so they actually file a cert petition to the Supreme Court asking for relief. And they actually have a really interesting argument. Go next. So this is from the cert petition. This is a page from it, my highlighting, but it's from the petition. And they actually make a really interesting argument here. And this is what they say. They say, it is the custom and practice of the United States Supreme Court, manifestly for the purpose of maintaining an entirely proper show of respect and dignity in its presence, to require persons entering the courtroom to remove their hats. The court undoubtedly has the right to so require. It is a custom and practice as old as the court. Suppose two or more men outside the courtroom agreed to enter with their hats on and keep them on. When they carried that agreement into effect, they would violate a long-established custom and practice of the court. That violation would have been the result of their very improper and entirely censurable pre-agreement. So they say it's wrong. You're supposed to wear hats in the Supreme Court. They conspire not to wear hats. Bad lawyers, you should not be doing that. Could it be said, however, that they had thereby illegally conspired to defraud the United States of a right in violation of Section 37 of the Criminal Code? So it's an interesting argument. They're saying, look, we all know it's wrong, morally wrong. But was it in fact illegal? What is the law that put these guys on notice, the law clerk and his associates, that what they were doing actually violated the criminal code? And this has been an ongoing issue in criminal law for hundreds of years. And just about 10 years ago, actually about 15 years ago now, there was a big case involving some of the Enron guys, Lay and Skilling. Now, Lay passed away, but Skilling challenged some of his convictions in that case, saying, look, what I did at Enron was sleazy and wrong, maybe, but it wasn't criminally illegal. And you haven't pointed to any law that says it was. The law you're pointing to is simply too vague to permit that. And the Supreme Court of the United States actually struck down some of Skilling's convictions because they said, you're right. The law that the court, that the government is pointing to is not specific enough to have put you on notice. And that is the same argument they're making in this case 100 years ago. But unfortunately for Embry, go ahead and click. Cert denied. Supreme Court never explains why. They just denied cert. And so now the case is ready for trial. So think about this for a second. The activity happened in December of 1919, maybe a little bit in November of 1919. It's worked its way through the legal system. You know how, I apologize, the courts can be slow. But now 2 years later, you're ready to go. Next. But nothing happens. The trial never happens. So did they plead guilty? No, honestly, it's kind of a mystery. So we're gonna have a bunch of clicks here, Ian, so let's go next. So the trial never happens. Next. So let's pause here. So in 1923, so this is a year and a half after cert was denied, there's a story in the local papers about how the DC court docket was very crowded, very jammed. And they specifically referenced this case as an example of a case that people have been waiting to see tried, but it hasn't happened yet. Let's go next. The case, the criminal prosecution against Embry and the others was completely dismissed in 1929. And when you go back and look at the docket books, and they're the old-fashioned large docket books with the pen entries, there's one mention in like 1925 of one of the defendants' bail being reduced. And like, that's it. So the activity in 1919, cert denied 1921, and then 8 more years, and this case is dismissed. Let's go next. I read through all the case files I could find, and we'll talk about at the end if you guys are curious as to how I came across this whole story. There's no closeout memo that I could find explain what the heck happened. Let's go next. So my theory is that one of the biggest reasons why this case fell apart, and there are a few other reasons why I think the case had trouble, but I think the biggest problem was the source that they had. That source I kept referring to, the source with the dictograph and who went to the reporter and was proposed about the military equipment. His name was John Hammond, and he had a lot of problems, let's just put it that way. But you don't have to take my word for that. Let's go next. Let's go, I mentioned variance, let's go next. He has a very interesting family tree, and we'll talk about one of his main critics. So here's his family tree. Let's go next. So John Hammond, next. His son was named John Hope Hammond. Now, this is a family story. John Hammond worked in the newspaper business. That's how he knew this guy Pugh, the one who went to the Supreme Court justice and knocked on the door. And the family story is that John Hammond ran something in one of his newspapers about Al Capone that Al Capone did not like. So next click. So there, you guys have seen that picture before. Al Capone has his guys kidnap John Hope Hammond. Eventually, an agreement was worked out and John Hope Hammond was released. But I think John Hope Hammond had had enough of his dad. So John Hope Hammond, let's go next, changed his name to Richard Halliday. Halliday was a family name. Halliday became a very well-known Broadway producer. And he ended up marrying, let's go next, Mary Martin of Peter Pan. Now, a little bit before my generation, but my parents' generation, Mary Martin was a huge star, huge star. And she actually had a very famous son. Go next. Larry Hagman. So for those of my generation, y'all remember J.R. Ewing from Dallas? Yeah, this is a family tree. John Hammond was in some respects Larry Hagman's granddad, but little family story here. So the family story is that John Hammond had suffered from severe mental illness. And in speaking with Larry Hagman's sister, she said at once upon a time, they had a box of all of John Hammond's personal effects, his notes, his journals. And when the sister was having a hard time in her life, someone said, well, sister, you think you're having a hard time, you should go see what your grandpa Hammond was going through. And so they actually kept these things as a reminder to the family that, that things were not always great in their family's history. And so I asked him, well, do you still have that box? I would love to see his notes. And unfortunately, the box had been chucked. So that was too bad. So I've said the family thought he was unstable. I think they're right about that from everything I've read, but you don't have to take my word for it. Let's go next. You can take this guy's word for it. Now, what the heck does J. Edgar Hoover have to do with this story? Well, that is a very young J. Edgar Hoover, as you can tell. And as a very young man, he got involved in this case. So let me set the story for you, or set the atmosphere here. So we mentioned that John Hammond was kind of all over the place. He was a kind of a failed newspaper reporter. He would claim to know a lot of people. He claimed to have a lot of money, which is kind of how he fell in with the crew in this case. And during World War I, he was alleged to have been working with German sympathizers as a lobbyist or in some fashion. And so I believe it was the Saturday Evening Post, which once upon a time was a major publication, ran a story talking about people who collaborated with Germany during World War I. And the story, in a kind of not very veiled reference, made it pretty clear that Hammond was one of the people that they felt was collaborating with the Germans. Hammond got very upset about this, understandably. So then he sued the Washington Evening Post for defamation. Talk about how maybe this is not the best way to run a law enforcement agency. The head publisher of the Washington Evening Post, the Saturday Evening Post, excuse me, then reached out to the Justice Department and said, hey, this guy is suing us. He claims to have done work for you in the past. Can you guys give us the dirt you have on John Hammond, because he's suing us and we want the dirt? And so based on that, this young attorney in the Justice Department, J. Edgar Hoover, was tasked with writing a lengthy report on John Hammond. So we go next. And here it is. Here's the memo. He's attaching this memo on John Craig Hammond. And notice the date. The date is May 3rd, 1921. This is while the case is pending before this, or soon to be pending before the Supreme Court of the United States. In fact, cert petition might have even been filed at this point. So during a criminal prosecution, where you're relying on John Hammond to be your big witness, to deliver the goods on the bad guys, you have the same Justice Department investigating him because a magazine is upset that he's suing them. So this is a completely messed up situation. So let's go next. So here's what J. Edgar Hoover is writing about John Hammond. He's saying John Hammond is a great bluffer, toots his own horn continuously, is a man of violent likes and dislikes and very vindictive, nourishing grudges against persons for a long time who may have done something to him to which he takes exception. In some ways, he is eccentric almost to the point of lacking good mental balance. Again, this is the government talking about its own witness. This is not a good situation if you're the prosecutors assigned to the Ashton Embry case. These days, if a memo like this was ever generated, the memo, at least in some form, would have to be immediately turned over to the defense, because it's what would be called giglio information, or information that discredits the credibility of John Hammond. So this is a very strange situation. Let's go next. And this is kind of the last paragraph in the memo that Hoover writes about Hammond. And he basically, the memo trashes Hammond, talks about how he claims to have all this information. None of it's true. He talks things up to make himself look important. What's interesting is the third paragraph, the last two paragraphs, actually, the third paragraph, which I'll read. The only thing he definitively and positively accomplishes for the government was his development of the Supreme Court leak. So Hoover thought that was true. Interesting. They said all other matters, basically nothing happened. The last paragraph. This is great writing, but brutal. I am informed that the last heard of Hammond was that he was living in Los Angeles this winter, broken in spirit, health, and purse. That's a great closing line for those of you who appreciate writing. And as lawyers, we always want to see good writing. I will say, as a judge, that sentence was well done. And that's what happened to the guy. I looked and looked and looked for any record of John Hammond, and he just completely falls off the map. Last thing I could find was I was able to find his personnel file. So what happened with Hammond was he was able to convince some people in the government that because he helped with the Supreme Court leak, he could help them find other fraud in military procurement. Recall that's how he got connected with these guys was the sale of excess military equipment. And then he claimed he actually got an ID number, M113 or something like that. And he claimed he was going undercover to root out this corruption, and he wasn't turning up anything. And the department eventually said, look, we're terminating you as an asset or a source for the department. You need to return all your badges. And he would refuse to return the badge. He said, you have to call me by my code name. It was all very, very strange. And in fact, the military official who kind of put up Hammond for this position later was transferred to Alaska, I believe. I think largely because of the failure of Hammond, and just it was embarrassing. So Hammond, doesn't work out. But whatever happened to Embry? Whatever happened? The case was dismissed. What happened to this guy? Let's go next. It was true. It turns out that he was a very successful baker in Washington, D.C. So maybe his excuse was true. Maybe he was having too much to do at the bakery. Let's go next. So this is a family photo of him on the left hand of your screen. You'll see the guy in the middle looks a little bit like Harry Truman. That's Ashton Embry. And kind of seated to his right on the edge of the couch, not the far right, but like the right near the portrait, the guy sitting near the portrait, that's his son, Ashton Fox Embry II. So you might see this and you might say, hey, well, look, this guy, he worked at the Supreme Court, and obviously he had this hiccup in his life, but life went on and he had a very successful career. You can see his nice family here. He moved on to the Supreme Court. And that's true. I mean, you can see the ad here in the middle talks about his very successful bakeries. They were called the Barker Bakeries. He had 5 locations in Washington, D.C. He also had a pastry shop. So he did well. But he didn't totally move on, if we go next. Because if you believe his family, when he died in 1965, his ashes were spread at night at the Supreme Court. So it's kind of a wild story. So we talked about Ashton Embry. We talked about Ashton Fox Embry II. That was the gentleman seated on the edge of the couch. Has that name gone on? And the answer is yes. So we click next. This is Ashton Embry III. And Ashton Embry III is a scientist, a geologist who lives in Canada. And actually, if you Google Ashton Embry, you will not find stuff immediately about this case. You'll find stuff about this individual, Ashton Embry III, who has written a lot about kind of treatments for, I believe, muscular dystrophy. Interesting guy. Or not muscular dystrophy, another serious ailment. I'm slipping my mind, but he's an interesting guy. So I've corresponded with him, and here's what he wrote to me. John, nice to hear from you again. We all still have a good laugh about my grandfather and his Supreme Court days. I suppose it was pretty small stuff compared with all the goings on in the world of finance these days. This is what part I love. One of my sons named his son Ashton Fox Embry IV, and he tells people he named him after the first insider trader. So, hey, the story just keeps on ticking. So I do want to open up to if people have any questions, but one question I'm often asked is first, let me talk about the significance. Remember the thing I said at the very beginning about the date 1916 and McKenna put the wrong date on there? Why do I think that's significant? Well, if you look into the life of Justice McKenna, it was clear by this time frame, 1919 or so, he was not up to the job anymore. He was slipping. And that happens. And as judges, we have to be cognizant of that everyone slips, and sometimes you slip too much and you shouldn't be in the job anymore. He had slipped too much. In fact, he was very protected by Chief Justice White, his good friend. Once Chief Justice White passed away, former President Taft became the Chief Justice of the Supreme Court. He came in and basically said, McKenna, you got to retire. You can't hit the fastball anymore. And there's actually a letter that's been found since then of the justice basically telling McKenna, you got to go. So kind of a sad ending to McKenna's career. I raised this because first, the 1916 thing to me is a slip that maybe he's not totally with it anymore. But second, it would have made it a lot easier for Embry to get away with this during this time if he knew his boss wasn't really paying attention, right? It's a lot easier to rob your boss when their mind's not totally in the game. So I do think that that's significant. I think another reason why the case fizzled was because Chief Justice White passed away and McKenna basically couldn't hit the fastball anymore. So two of the witnesses you would want to have it come in and testify about how serious this was of a breach of what happened at the court, they're gone. And Chief Justice Taft, he doesn't want anything about this. It's not good for the court as an institution to have a criminal trial talking about how screwed up things were at the Supreme Court. Embry claimed one of his defenses was going to be, wasn't me. All these other people were very loosey-goosey with, very important Supreme Court documents. It would have made the court look really bad because his defense was going to be, I wasn't the source. These other people were the sources of the leak, some other how. It could have happened a million different ways because the court is so poorly managed. Not the story the court wants to tell. People often ask, do I think he did it? Yes, I do. I'm convinced that he did it. And in fact, one of the interviews that I uncovered talked about how he acknowledged the night before the trading, he received $500 from his bakery partner. $500 back then was a lot of money. And the bakery partner gave him that money the night before the trade. He really had no explanation for how it happened. And it just makes perfect sense. And his resignation obviously didn't help matter. So I'm convinced he did it, but proving it in court is a very different thing. You had the problem with the source. You had the problem that your sympathetic witnesses are not available anymore. I don't think anybody really wanted to touch this thing anymore. So it quietly just vanished. And so Ashton Embry was able to live on his life as a baker. I could never really figure out what happened with the other guys, but none of them went to jail. So that's the story of Ashton Embry. So for, again, younger lawyers on the call, you can see how someone at a tech company gives you information or you're working on a matter, just don't, I've made some jokes or this thing, but obviously this is very serious. You will get in big trouble like the guy at Qualcomm did. So Joe and Ian, if anyone have any questions, I'd be happy to answer questions. And when I talk about questions, Joe, I can talk about this case. I can talk about the Supreme Court. I can talk about being a federal prosecutor, the Ninth Circuit, which is where I serve now. 15 minutes, I can talk about anything people would like to hear.
Sure. I don't see any questions yet, but I'll let some people take a couple minutes and see if they can't come up with some that I can lob over to you. But
Sure.
I was a little interested in some of those prosecutions that ended up on American Greed. So I don't know if you could briefly touch on maybe one or both of those.
Yeah, so they both were similar in the respect that they both were straight Ponzi schemes, right? And the bigger one was this one case called Treadwell, and he ran a company called Learn Waterhouse. And he would come to these meetings. You see these things advertised sometimes. Come to learn about investment opportunities, and it's like at a Holiday Inn or at a church somewhere. And he would go to these things and he would say, hey, look, I've made millions and millions of dollars, but I'm a very religious man. And so I want to help fellow Christians. This is a common theme, affinity fraud. They try to break down your resistance because I'm a fellow Christian, or I'm this, or I'm that, and so are you. So I wouldn't cheat you. And he would say, I've made so much money doing these things. I don't need to work anymore, but I just want to help the little guys like you. And so my plan, it involves banks and all this kind of nonsense that you would hope people would say, well, that's ridiculous. You're not going to get a return of 10% a month guaranteed. That's crazy. But the crazy thing about it is that people who are relatively sophisticated actually did get involved in this. And I think it's a classic nature of a Ponzi scheme where people, the way a Ponzi scheme works is that if I'm the bad guy, Joe, I say, look, I'll give you 10% a month. You'll earn 10% of a month. If you give me $1,000, you get $100 a month. So you give me the $1,000 and I'm just paying you out of that money, right? So you give me 1,000 and the next month I give you 100 and you go, wow. And I'll give you like an official looking account statement, right? That says that. Then what will happen will be you'll tell your friends, this is for real. And then they give me the money and then they give me the money, they give me the money. And it just keeps happening over and over again. And as long as people keep giving the money, it will keep, working per se. And you're getting your $100 a month. So maybe you give me more money because you're really convinced this works. Eventually it comes to a screeching halt, right? Because eventually there's no more money coming in. But during that time, I'm then diverting this money and doing whatever I'm going to be doing with the money. And that one was big. It was all over the country. And the reason why it was in San Diego largely because we had some investors in San Diego, but we had a really good undercover. Two things. We had really good undercover agents in San Diego got on the phone. We had great phone calls with these guys, which really lit these guys up. But we also had this guy who was a convicted fraudster himself, no doubt about it. But he really knew how to talk to these guys. And we got him on the phone with them as well. And so when you had the experienced undercover agents that we had, and also this convicted fraudster who knew how to talk, he knew what would appeal to these guys. It was a pretty compelling story. So yeah, so that one aired on American Greed, and it was one of those things where, in my life, people usually, when I walk down the street, people don't, if they're a friend of mine, they recognize me, but I'm not like a celebrity or something like that. But on that case, one time I was at Union Station in Los Angeles waiting to come home. So when I worked at Munger Tolls in LA, I commuted from San Diego. So I live in the Scripps area. Okay. So I would commute, I would drive up to Solana Beach, get on the train, take the train up to LA and come back, right? So one time I'm in the train station and this guy walks up to me and he says, "Hey, I've seen you before." And I'm thinking like, oh man, this could be it, right in the middle of the Union Station. For those of you who've been to Union Station, I love the train station, but every once in a while I got some questionable characters walking around there. And he said, "You're the one who was on American Greed." And I said, "You're right, I was." I was a little worried that he was gonna, say, "You put me in jail or you put my brother in jail," but no, he was very excited to talk about American Greed. So thank goodness that was the one time I've been recognized like that in public.
Awesome. I don't see any other questions, but I was going to ask you another one, if that's okay.
I think we got. Did we get a question? Oh, just a thank you. Thank you from Keith. You got it, Keith. Go ahead, Joe.
Sure. Kind of just back to the Embry case. What kind of got you interested in this to begin with, or how did you catch wind of it? Or it's like happened so long ago, and I mean, you were able to find out so much about it. Kind of, how did the interest arise, or how did you even hear about it?
Yeah, well, it's a strange thing. So I was a law clerk at the Supreme Court in the 1997 terms, in 1997, 1998. And during my term, a book was written about a law clerk's experience at the Supreme Court. It was called Closed Chambers. And it was a very controversial book in the Supreme Court community because the author of the book was relating conversations he had with Justice Blackmun, relating decisions Justice Blackmun made. And that, that's almost like attorney-client. Right. And you guys know is that you can't be broadcasting conversations you have with clients. And that's kind of what he did. So the Supreme Court was outraged. So that book came out, and the next day, Chief Justice Rehnquist wrangled us all the law clerks into a conference room, and he had that book in his hand, and he was really mad. And he basically said, "You can do this, you can never do this." So then coincidentally, that term, 3 novels came out about the Supreme Court. And they were like law clerks doing bad things at the Supreme Court. So you had a law clerk who actually did a bad thing at the Supreme Court. Then you had 3 novels, which law clerks did really bad things at the Supreme Court. So I said, you know what? I'm going to write a book review about all of these books. And it'll be easy because I was probably going to read the books anyway. And I'm at the Supreme Court. And if I was ever going to do a book review, this would be time to do it. So I did the book review. But in the process of doing the book review, I said, I actually want to know something about the history of law clerks. So I said, I'm going to try to find some older law reviews about the history of law clerks, see what I can learn. So I read this article from 1960 in the Oregon Law Review, written by a guy named Chester Newland. And Mr. Newland, in a footnote, referenced this Ashton Embry case. And I was like, what? I'm at the Supreme Court right now. We just had the law clerk accused of leaking the decision, the conversations with Justice Blackmun. How did this never come up? And so I started asking around, and no one had heard of this. No one, Chief Justice Rehnquist, who was a law clerk himself and a real student of the court, had never heard of this before. And so I said, I got to find out more about this. And so I did write the book review, But really where my focus went was towards this story. I had to get to the bottom of this story. And so I spent a lot of time doing that. I was, at the time I was engaged, not married, no kids. I lived in Washington, D.C. So it's actually the perfect time because I wasn't running around trying to find a girlfriend or a wife. I was engaged and I had no kids. So I wasn't tied up with soccer practices and basketball practices. And so I would go to work. I just finished at the Supreme Court. I would work at the Justice Department during the day. And then at nighttime, I would drive out to Archives 2, which is the National Archives location on the University of Maryland campus. And it was just painstaking work because when you go to Archives, you can't just say, give me everything about this guy. You have to request a specific document. They then bring you that document. You can look at it. You can't photocopy it. And this is before cell phones taking pictures. So you couldn't do any of that stuff. You had to request a copy of it. And then they would make a copy of it for you. And then if you saw a number in that document, like a file number, you then had to make a request for that document. And then maybe you have to come back the next day. So, none of this is online. This is all the old fashioned way of doing things. I really had to get to the bottom of this because I just was so like, how did this happen? And in fact, the only person at the Supreme Court that I encountered that had any knowledge of this was there was a woman in the library who started there in the 70s. And she said when she started in the 70s that some of the old timers told her, hey, when you work in the library, and this is very true, the librarians have access to actually all kinds of inside information because on opinions, they're requested to look up things. And they said, you're going to come across very important information in this job. You got to be very careful because there was a guy here who got in big trouble when he tried to make money on it. And that was the only person at the whole institution that seemed to know anything about this. So it was, I don't know, it was swept under the rug. I mean, it's not something you really want to advertise that this happened. This is very embarrassing. And, there have been leaks since at the Supreme Court, but usually it's after an opinion comes out, people talk about why the decision came out a certain way. I don't think there have been at least any public allegations of insider trading based on these things. I think that there's a huge, if you're a law clerk of the Supreme Court, as long as you don't blow it, you've got a very, very bright future ahead of you career-wise. And if you blow it, that's all gone. So you don't have the incentives to do something stupid like Embry did. Well, when Embry did it, he wasn't making that much money. There wasn't this pipeline to, big firm partnerships like there was back then. So, for $500, he was going to do it. Nowadays, for those of you who are kind of aren't in the loop on these things, the signing bonus for associates, if you have the Supreme Court law clerk, if you go to like a Jones Day, over $400,000 today, 400 grand is a signing bonus. So now you're probably not going to do that. I guess is what I would say.
Yeah, that's not small. Does anybody else have any questions for Judge Owens?
We got a couple more here in the chat. Let's see here. We got, okay, so great. Were there any professional sanctions consequences imposed on Embry? As far as I can tell, I couldn't find any. I think he did resign from being a lawyer, but he could easily just put that off as, well, I'm a baker now. And he was a baker. So, he actually had a good story about that. I didn't see any kind of DC bar stuff against him, but I don't think he was a practicing lawyer. I didn't find his name listed in any of the old like phone directories, which is where I found out a lot of the stuff where he ended up being. I didn't see anything about attorney at law. It seemed to always be the bakers. And then I saw Ian Friedman had a question for Justice Ginsburg stories. Well, yeah, I've got a lot and I know we're out of time, so I'll give you a quick one. So, people often ask me, what was she like? And I often say that I've never met anyone who was as tough as she was. Now, I say tough, I don't mean mean. She was not, she's very nice. But she had such fortitude, such grit to overcome all the things she overcame. It was just remarkable. And she never made excuses, right? Because she came up in a generation where if you were a woman and if you blew something on an assignment, that was it. You didn't get a second chance. So she never made excuses. She was always on time. She was always prepared. And candidly, really good role model for young lawyers because, these days people make excuses for everything and you never heard her make excuses. So here's the story. So there's a a case we were working on, and I told this story in front of her, which is why I feel comfortable telling it now. Where she and I disagreed. And look, part of the job as a law clerk is to disagree with the justice, right? I'm not a yes man. I have law clerks down. I tell them, look, if you think I'm wrong, your job is to tell me, much like a lawyer tells a client, I think you're wrong. I don't think you should do this. But ultimately, it's the client's decision. And ultimately, it's the justice's decision. And there's some point where the law clerk or the lawyer needs to shut up. You've said what you had to say. You got to stop. So I was telling her I thought she was approaching this case incorrectly. And eventually she said, that's fine, John, but I'm the justice and you're not. And so, as a young man, I took that hard. That was a hard conversation to have. But in hindsight, now that I am a judge myself, I now understand what she was trying to say. What she was trying to say there was, part of it was, look, law clerk, you need to be quiet. And look, everyone needs to know there's a time you got to zip it. But what she was saying is that she had the commission from the president of the United States. She was the one that the Senate confirmed. She had to feel comfortable with the decision. That's why she's there. And if she didn't feel comfortable in the decision, then that was it. And she had to explain why. And now that I'm in this job, I understand what she was saying there, along with putting a law clerk in his place, and rightfully so. So that happened, that conversation happened in like December of 1997 or January 1998, somewhere in that time. I told this story, I believe in 2018, maybe beginning of 2019, at the University of Pennsylvania. They were doing a kind of a ceremony for her. And I told it in front of the law clerk, I told it in front of students, and she was there. And she, after I was done speaking, she said, in that case, Justice O'Connor wrote the majority decision. And I thought to myself, hold on a second. One, that's correct. Two, how does she remember that? 20 years later, hundreds, actually probably over 1,000 opinions since then. All these law clerks she's had, how does she remember the case? I mean, I can't remember stuff that happened yesterday. How does she remember that? And I don't think it was because it was such an extraordinary conversation. It was an extraordinary conversation for me as the law clerk, but for her, it's not. She just had that amazing intellect in her. And that was when she was 84, 85 years old. And she still knew it like it happened yesterday. So truly just amazing in that respect. Just such an amazing person, an amazing intellect. So, obviously I still speak of her as she's still with us. Obviously she's not, but I think that the lessons she taught, the influence, means she always will be there in some fashion.
Awesome. That's a great story. Thank you, Judge.
Sure.
Well, I think that's we're at 12:59 here, so I think we're at the end of our time. So, Alan Brubaker, another thanks, Judge. Thanks, Alan.
Sure.
And, if there's no other questions and we're at the end of the time, I think we're ready to wrap it up. I just want to thank you so much again, Judge, for setting aside the time and giving us the presentation today. It was extremely interesting. It's not like the normal presentation we listened to, so it was extremely interesting to hear, and to know that you're the one that kind of uncovered this and did all of the investigation afterwards. So really cool to hear the boots on the ground description of the investigation.
Yeah, it was one of those things that I got a hold of it and I couldn't let it go. And we're here 20 years later. I'm still talking about it.
That's awesome. Well, thank you again. Thank you again, Your
Sure.
Honor.
Take care. I hope to see everyone in person.
Bye, everybody.
Bye-bye.